As it was said, topic of my presentation and of my future chapter is international law and EU law in the constitutional system of Hungary. In this presentation, of course, I focus both on international law and EU law separately, talking first about the provisions in the Hungarian constitution, about international law, following with the case law of the Hungarian Constitutional Court, and then after it, I will talk in the same way about law of the European Union. Let's start with international law. Here, I would like to start from, let's say, a historical perspective, talking first about the provision that existed in the previous Hungarian constitution of 1989. Now I gave myself the freedom to call this constitution like that, knowing that it was the constitution from 49, which was radically amended in this year after the round table negotiations. Since these amendments were radical, it affected almost 80% of the constitution. I can use this expression, this name, Constitution of 1989.
Ivan, sorry, and I would like to ask the others. Can you see the third slide on the screen? The others, the international law and the Constitution.
No.
Huh? Okay.
Just a second, we will manage it.
Okay, thanks.
What about now? Is it different?
Still cannot be seen.
No, it's not the first slide.
It's really interesting
moving,
because I can switch. You know, for example, this is going to be my the test. Okay.
Now it's the same, or just a second.
Now it works.
It works. I can change your slides.
It works. Okay, I can continue. So about the Constitution from 1989, in Article 7, there was a provision stating that the legal system of the Republic of Hungary accepts the generally recognized rules of international law and shall harmonize the country's domestic law with obligations assumed under international law. With the adoption of the new constitution called the Fundamental Law in 2011, Article 2.3, Paragraph 3 states that the Hungary shall accept the generally recognized rules of international law, while other sources of international law shall be incorporated into Hungarian law upon their promulgation by laws. And what is specific when it comes to international law compared to European law is that the case law of the Hungarian Constitutional Court that was established already in the first decade of its activity in 90s gave the crucial interpretations about the mutual relation between international law and Hungarian domestic or national law, which are valid also today. While on the other hand, for EU law, it is possible to notice the graduation, that the interpretation of the Hungarian Constitutional Court changed starting from the beginning of the century. So when it comes to international law, decisions of the Hungarian court which are crucial are the following. First, let's start with the decision that was rendered in 93. In this decision, essentially, the Hungarian Constitutional Court stated that the generally recognized rules of international law form part of Hungarian law even without any separate or further transformation, meaning that the transformation of these rules, of the generally recognized rules of international law, was done in a general way, without precisely defining them by the Constitution itself. And consequently, they are not part of the Constitution, but obligations undertaken. Also, in addition, the Hungarian Constitutional Court opposed the generally accepted rules of international law as instrument for interpreting the Hungarian Constitution and domestic law. We can conclude that these rules are essentially handled in a monistic manner. I mean, generally recognized rules of international law, since they are generally transformed by the Constitution itself. So here it is the case of the monistic approach and the general transformation. But when it comes to international treaties, the approach is different. It is the dualistic approach that is applied in Hungary, since a separate or specific transformation through the statutory promulgation is needed and required in order for these international treaties to become part of the Hungarian legal order. This decision from 1903 posed the foundations of this conception, which is called as the general adoption of the dualist system. It is accepted in the following decisions of the Hungarian Constitutional Court. What is the novelty is the decision from 1998, which made an explicit reference to the norms of international jus cogens, peremptory norms. Why this is very important? Because it gave a different interpretation about the mutual interrelations between the sources of law. Because what is a general rule is that the Hungarian Constitution is the supreme or the highest legal act. But the Hungarian Constitutional Court in this decision, so in 1998, stated that international contractual commitments falling outside the scope of international jus cogens rules may not prevail in their content contrary to the Constitution. It is not stated directly, but if we use the argumentum a contrario interpretation, we can say that the international jus cogens was put higher than the Hungarian Constitution, and that is the only exception of the rules. That is the only exception. So just international jus cogens, which is interpreted as higher than the Constitution, the only exception. And it is, as I saw, from the last decade of the century, of the previous century. And about the legal position of jus cogens, it was also confirmed in the decision from 2018. It was said that the norms, principles, and the fundamental values of jus cogens together form a standard that all subsequent constitutional amendments and constitution must meet, while Article Q of the fundamental law is to be interpreted in a way that the sovereignty restricting effect of international law is realized due to the state self-restriction rather than by way of a legal order placed above the states. So, as a general conclusion about the international law, it would be said that the generally recognized rules of international law are accepted in the Hungarian system using the monistic or monist concept approach, and what is acknowledged in the Hungarian legal theory is that customary international law, peremptory norms, or international use cogents, and general principles of law recognized by civilized nations are included or subsumed under this term, generally recognized rules of international law. While the term other sources of international law from Article Q of the Fundamental Law comprises international treaties, binding decisions of international organizations, judicial decisions, and unilateral act of states. And in this case, the dualistic approach is accepted in the Hungarian legal system. And also concerning international law, what is crucial to mention now is this decision also from the first decade of the activity of the Hungarian Constitutional Court from 1998, where it is said that the potential determination that the international treaty or any of its provisions is contrary to the Constitution would result in declaring the legal act promulgating that international treaty unconstitutional. But this cannot have an impact on the international commitment of the Republic of Hungary. And consequently, the Hungarian legislator must establish the harmony of the international legal obligations undertaken and domestic law. The Hungarian Constitutional Court identified in which way this needs to be done. It may be done either by the Republic of Hungary denouncing the part of the international treaty that is contrary to the Constitution, or by obtaining its amendment, or if necessary, by amending the Constitution itself. So, as I said, the foundations for the interpretation of international law that are valid also today were posed by the Hungarian Constitutional Court in the first decades of its activity. When it comes to the European law, it should be mentioned that when there were these huge amendments of the Constitution in 1889, there was no reference to EU law. But why then it was introduced later in the Hungarian legal system? Also, in this case, the huge role is given to the Hungarian Constitutional Court, which in its decision 3099 treated European law as a foreign law, and it also exists. The court also demanded the existence of a separate constitutional authorization for the EU law as a foreign law to be applicable in Hungary. And the court also stated that Parliament cannot make a hidden or a covert constitutional amendment by concluding or promulgating an international treaty, the Europe Treaty in this specific case from 1994. So after this decision, there were amendments to the Hungarian Constitution in 2002, which resulted in the introduction of the accession clause. Just a second. In that moment, when it was Article 2A of the Hungarian Constitution, accession clause stated that the Republic of Hungary may, in order to participate in the European Union as a member state, based on an international treaty, exercise some of its powers arising from the Constitution to the extent necessary for exercising the rights and fulfilling the obligations stemming from the treaties founding the European Union and the European communities, jointly with the other member states. The exercise of these powers may be carried out independently, also through the institutions of the European Union. What is evident, what can be seen from this article, is that the Constitution did not explicitly mention the transfer of the sovereignty to the supranational institutions, but the joint exercise with other member states of certain constitutional powers to together with independent exercise also through the institutions of the European Union. The legal basis that would render possible this joint exercise of certain constitutional powers was an international treaty which had to be ratified in the Hungarian parliament by 2/3 majority of the members of the parliament. And also the accession clause pose a so-called purpose limitation, that this had to be achieved in order for Hungary to participate in the European Union as a member state. When it comes to the adoption of fundamental law in 2011, it should be said that at least in that moment, when this act was enacted, there were no big or radical differences compared to the accession clause from the previous constitution. It stated that with a view to participating to the European Union as a member state, so it is the same purpose, with the same purpose limitation as the previous, for Hungary to be member, to participate as a member state, and on the basis of international treaty. So international treaty again, and again, a 2/3 majority is needed for this international treaty to be ratified by the Hungarian parliament. Hungary may, to the extent necessary to exercise the rights and fulfill the obligations deriving from the founding treaties, exercise some of its powers arising from the fundamental law jointly with other member states through the institutions of the European Union. What is different compared to the previous constitution is that the joint exercise of certain constitutional powers is mentioned, which is done as through the institutions of the European Union as the appropriate arena for this kind of joint exercise. While, as you can see in the accession clause from the previous constitution, it was joint exercise together with independent exercise. What is a novelty already in the moment of the enactment of fundamental law was the provision that the European Union may lay down generally binding rules of conduct. What is also specific and a common point between these two legal provisions from two constitutions is that they do not refer to the main features, to the principal characteristics of European law. For example, the direct effect, direct application, or the principle of primacy of EU law are not mentioned nor referred to in these provisions. As a novelty that was introduced with the constitutional amendments in 2018, which are fruit again of the case law of the Hungarian Constitutional Court, is the expansion of the accession clause with the following provision, with the following sentence. The exercise of competencies under this paragraph shall comply with the fundamental rights and freedoms enshrined in the fundamental law, nor shall it limit the inalienable right of Hungary to determine its territorial unity, population, form of government, and state structure. These, let's say, fundamental reservation of the fundamental rights and the constitutional identity essentially were proposed as a restriction or limitation to the joint exercise of competencies. When it comes to the case law of the Hungarian Constitutional Court, as I previously noted, that it changed in the last, let's say, 30 years around regarding the EU law. As I already mentioned, this decision from 1998, which urged the need for the inclusion of accession clause in the constitutions. After Hungary became member state of the European Union in 2003, what should be mentioned is this decision of the Hungarian Constitutional Court from 2005, where the court said that it would not treat the founding and amending treaties of the European Union as international treaties, despite their contractual origin, in which sense, this way it established a trifurcated system where there was European law, international law, and domestic law. Already next year, with the decision from 2006, it stated that the founding and amending treaties of the European Union as primary sources of law and directives as secondary sources of law form part of domestic law as community law, since the Republic of Hungary has been a member of the European Union since 1st of May 2004. And also the court emphasized that from the point of view of the jurisdiction of the Constitutional Court, community law does not qualify as international law as defined in Article 7 of the previous constitution. And it should be said that in the first years after the accession of Hungary to the European Union, after it became a member state, the Hungarian Constitutional Court ignored the European or communitarian origin of impugned domestic legislation. But in this decision from 2008, but it's called like this, like it's written in 2005, it's written that a potential collision with EU law belongs to the competence of the organs of the European Community as the last instance, and the European Court, the European Court of Justice, Court of the Justice of the European Union. But when it comes to the case law of the Hungarian Court of Justice, the radical change compared to the previous case law started with this decision from 2016, where the court introduced this reservation of fundamental rights, stating that the fundamental rights are prioritized over the enforcement of everything else, sovereignty control, also introducing the so-called presumption of the maintained sovereignty, meaning that Hungary did not leave its sovereignty when it became a member state of the European Union, but rather permitted the joint exercise of certain constitutional competencies. And consequently, it is to be presumed that Hungary maintained its sovereignty when deciding upon the joint exercise of powers additional to the rights and obligations contained in the founding treaties of the European Union. Together with this reservation of fundamental rights and the sovereignty control, the Hungarian Constitutional Court was mentioning the identity control or the protection of constitutional identity. And in this specific decision, it mentioned as part of Hungarian constitutional identity freedoms, these characteristics: freedoms, separation of powers, the republican form of government, respect of autonomies under public law, the freedom of religion, the legitimate exercise of power, the parliamentary system, equality of rights, recognition of the judicial power, and protection of the nationalities living in Hungary. As I previously mentioned, this decision provoked the constitutional amendments that I had previously mentioned from 2018. And the Hungarian Constitutional Court also said that this institution is permitted to examine whether the joint exercise of powers constitutes the violation of human dignity, the essential content of any other fundamental right, the sovereignty of Hungary comprising the extent of the transferred powers, and the constitutional identity of Hungary, based on a relevant petition in exceptional cases and as a matter of ultima ratio, along with paying due respect to the constitutional dialogue between member states. The Hungarian jurisprudence of this court after this decision was in the same light. It gave more and more specific interpretation to all these features: identity control, sovereignty control, reservation of the fundamental rights. But in that period, so from 2016. So from 2016 until today, this decision from 2021 proved to be the most important. So in this regard, it of course also mentioned the reservation of fundamental rights, and the court outlined that ineffective joint exercise of competencies under Article 8, paragraph 2 of the fundamental law could lead to foreign populations permanently and massively staying in the territory of Hungary without democratic authorization, which would constitute the violation of the right to identity and self-determination of the people living in Hungary. Regarding the presumption of maintained sovereignty, the court stated that this presumption is undoubtedly applicable to all powers that are not determined in the Treaty on the Functioning of the European Union as being the exclusive competence of the European Union. And what is, I would say, the most important interpretation that was given by the Hungarian Constitutional Court in this case is the following: that the Hungary is allowed to act unilaterally with regard to the joint competencies when the lack of exercise of the common competence is concerned, or their incomplete exercise, clearly failing to ensure the effectiveness of EU law, may lead to a violation of fundamental rights or a restriction on the performance of state obligations. This is possible only until the European Union and its institutions have created the guarantees for the effectiveness of European Union law. And this type of unilateral action must be in concordance with the founding and amending treaties of the European Union. And Hungary, as a member state, must bring to the attention of the European Union or its institutions the necessity of jointly exercising the competencies. With this, I would like to close my presentation, and I would like to say again that when you study this, when you study Hungarian constitutional regulation and the practice of constitutional law, it is really evident and visible how this interpretation changed, this distinguishing international law on one side and European Union law on other. And I'm sorry because of these technical inconveniences. I hope that it was possible to listen to my presentation clearly, and that it was not a big difficulty, this with my presentation. And thank you so much for the attention.